Greetings of the day. This is Anushka Gupta from Lawyered. I would like to welcome all of you to another session of Hashtag Mentor R on Guide to Consumer Protection Act 2019. Before starting, I have a small announcement for our viewers. Please mention your questions or queries in the comment box, and a link is shared with you. Please fill it up for attendance and e-certificate. So today, I would like to welcome K.V. Omprakash sir. Welcome, sir.
Hi.
Yes. So moving ahead, Sir is a corporate lawyer by profession who mainly focuses into business and legal advisory. He has been in the legal profession since 1989 with expertise in mergers and acquisition, legal and business advisories, and more. To add on, he is the founder of Conscientia Law Associates and Conscientia Consultancy Private Limited. Now, without a further ado, I would request Sir to please take over the screen.
Good afternoon, all. And today we are going to look at the amendments which have happened in the consumer laws. The topic given is Guide to Consumer Protection Act 2019. As all are aware, the consumer laws came into existence from 1986, and there has been a very great success story about the entire concept of consumer laws, and the law has been a very consistent, and the consumer protection has been kept in the mind, and there has been various judgments which have been passed by various consumer forums, district, state, and national commission. So after a long time or period, a new amendment has been introduced, keeping the phase of the technological development and the change of consumer behavior and pattern. So what does this act, the new amendment, brings us? What the next few minutes we are going to discuss about. And with this time constraint, I may not be able to get into the deeper sections and the entire amendment. But yes, definitely the features and highlights will be definitely discussed in this session. If you have any doubts, you can later on have it in the question and answer sessions. So few important thing is the highlights of this act is the consumer has been kept the same, but it has been this scope has been expanded. It has covered uh, hires or avail of any services, and it has also brought in online services, electronic e-commerce. So this has broadened the scope. That means you are purchased through e-commerce, teleshopping, all those things have come into the gambit of the protection. Now earlier these were not a nomenclature available, because at that point of time these things were not there. So the entire uh, act has focused on that. And if you see, there is a introduction of or non-inclusive use by the person of goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. So again, still it goes to B2C. So he should be a consumer. It cannot be resold or used for any commercial purposes. So it could be for a livelihood. So those people are called consumer. So this is the consumer definition, which has a broader scope, which has included the e-commerce and online purchases. Anushka, next slide, please. Normally, does the person in Consumer Protection Act include corporation or business community? Yes, again, we go back to the old act. It should be for the consumer's benefit and it could be for his livelihood. Otherwise, a business person cannot be a consumer. Next slide, please. Now, the various things which have been introduced under this new act includes establishment of Central Consumer Protection Authority, it's called the CCPA, to promote and protect and enforce the rights of consumers, which was not there earlier. So this authority is going to be set up or already set up, which will take care of the consumers' protection. The new act is also aiming at empowering consumers and help them in protecting their rights through the various notified rules and provisions like consumer protection councils, consumer dispute redressal commissions, mediation, product liability, punishments for manufacture or sale of products containing adulterated or spurious goods. The new things which has been introduced includes mainly the product liability. And what are the consumer rights which has been protected? The right to be protected from and kind of hazardous goods and services. The right to be fully informed about the performance and quality of and goods and services. The right to free choice of goods and services. The right to heard of any discussion or the decision making process, that right also is available for the consumer. The right to seek redressal for any consumer related product problems. The right to complete consumer inclusions. So these are all the rights which is being protected under this act, and you can say these are all inclusively and overall covered under the consumer rights. Next slide. Some new rights are right to file complaint from anywhere. So earlier there was a jurisdictional restriction. Now the consumer can file it from anywhere where he resides. Right to protect customers as a class. So class representation is also available under this amendment. Right to seek compensation under product liability. The product liability is one of the new provision which has been included under the act. Right, hearing through video conferencing. So video conferencing is allowed, but so far they have not started it. A few places they have started, but most of the places it's yet to start. Right to know why complaint was rejected. So earlier, if there is a rejection, you would not know that. Here now you can question them. Next slide, Anushka. So if you see the major highlights of the Amendment Act is the introduction of e-commerce product liability. False advertisement. Yes, the celebrities will be taken to task. The celebrities who are into making advertisement of products have to be very careful because they are liable. So if any of the advertisement turns to be false, then they will be taken to task. Pecuniary jurisdictions. There's a change in the amount as per the jurisdiction is concerned. So there is an increase. Bodies established under the new act. The new act introduces various bodies to govern the consumer protection. So these are the uh, main highlights of the new act. Next slide, Anushka. The main deviation or the inclusion which I can say is the e-commerce being brought in the gambit of the Consumer Protection Act. There were a lot of cases where companies like the aggregators like Flipkart, Amazon, they're also made parties, and uh, they would like to say that we are only an aggregator and we do not have any say on this. But now the entire thing has been brought into the Consumer Protection Act, and it also defines electronic service provider. So this is the biggest feature in the new act. The rules will be applicable to all electronic retailers registered in India or abroad, but offering goods and services to Indian consumers. So e-commerce platforms and acknowledge the receipt of any consumer complaint within 48 hours and redress the complaint within 1 month from the date of the receipt. The new act empowers the central government to make rules, take necessary measures to prevent unfair trade practices and secure the rights of interest of the consumers, also enabling them to proceed against the e-commerce websites in the event of any infringement of violation. So these are the e-commerce related provisions which the amendment has brought in. So next slide, Anushka. Yeah, this is the major thing. Now the manufacturers are liable for their product. So the onus is on the product seller as well, the manufacturer or the product seller. So they are liable for the defective product. Earlier it was only the warranty clauses were considered. Now they are made directly liable. So these online marketplaces, auction sites can now be held in product liability. So there are a lot of market places or online auction happening. So all those things are coming under the product uh, liability. So the aggregators also form in this area. If you see the online marketplaces and auction sites can now be held in the product liability action under the circumstances as stated in section 88 of the act. So that act, the section deals very elaborately concerning the increased liabilities risk for the product manufacturer. The act also provides exceptions from liabilities and claims. The new act defines harm and includes mental agony and emotional distress within its scope. However, it may create a gray area for verification of the presence of mental agony and extent. So normally the presiding officer has a discretion in this. So the quantum of mental agony has to be proved by the the complainant himself. So this covers the product liability. and which is a major inclusion in this Amendment Act. So the manufacturers and the product sellers have to be more cautious as the Consumer Act has widened its scope on that. Next slide. Now, when it comes to the steps by the companies involved in goods and services sector to avoid product liability, what are the steps? So, mainly these companies have to make clear warranties, disclaimers, and what is the product actually warranties, what is not covered in the warranty. If there is a service level, we should disclose that. So by this, they are very clear to the consumer, even at the beginning itself, that this is my responsibility, this is what my product is going to do. Anything beyond this is not covered under the product liability. Maybe some companies can make some insurances, they can cover their risk for potential consumer litigation in case there is a claim. So that can be done by them. Next slide. False and misleading advertisement. So this is one new deviation or amendment or term which has been included in this act. So this is first of its kind, and consumers are protected from false advertisements. So you cannot go by a celebrity talking about the products or making some advertisement which is not going to be real. So the amount, if you see the pecuniary, the punishment, penal amount, if you see, it's going to be 10 lakh rupees and imprisonment. It is not or, it is 10 lakh rupees and imprisonment for a term which may extend up to 2 years. Section 89 deals with it. So misleading advertisement is defined under the section 228, which says or includes, gives false description, false guarantee, express or implied misrepresentation, deliberately conceal important information. So concealment, express, implied misrepresentation, or false guarantee. These are the main conditions to define a false advertisement. And in case you are liable, the penal amount is mentioned as fine, or it also includes imprisonment. Next slide, please. Pecuniary jurisdiction. Earlier, the district forum, the state commission, and the national commission had a slab. So district forum had up to 20 lakhs. Now it has been increased to 1 crore. So all the consumer litigations where the claim amounts are below 1 crore, up to 1 crore, can be handled by the district forum, and above 1 crore to 10 crores can go to the state, and beyond 10 crores can go to the national. So this is the increment which has been introduced in this amendment. It's good actually, so that the district courts have a wider range of jurisdiction in terms of pecuniary limitations. Next slide, Anushka. Main bodies under the new act or the Consumer Protection Authority, Consumer Redressal Commissions, that is the CDRC mediation cells. So these have been introduced. Earlier there was no mediation cells. Now the parties can on mutual agree for a mediation cell, and a separate mediation cell will be constituted so that they can amicably settle. Earlier it was the advocates who is to handle this. So these are the new bodies which is going to come in place. It's yet to come. Let's wait and see. Next slide, Anushka. A consumer can conduct her own case via video. So this is normally even in the existing act, a consumer can represent himself without a counsel. Unless he is not able to present the case, the presiding officer or the member does not insist on an advocate to represent. But now here it is allowed in video. So this is a good introduction. Engaging a lawyer is an option. E-complaints are made available. There are a set of procedures to be followed. And untrade practices also have come under this gambit. So if there is any untrade practice followed by any manufacturer or service provider, the scope is there for under the Consumer Protection Act, and of course the authority which is going to be introduced is also a deviation. Next slide. So if you see the highlights, the old act and the new act, what are the remarkable changes which has been brought? We discussed on the pecuniary jurisdiction where the amount threshold has been increased. Territorial jurisdiction, now the consumer can file it from his place. He need not to come to the place where the registered office of the company or the manufacturer is there. So he can file it where he is liable, where he is staying. Product liability, as we discussed, the manufacturer or the market sellers are liable. Aggregators, online marketplaces, all these people are liable. Regulator, there's a change in the regulator. We are bringing an authority inside. Authority will take care of. They also have a power to investigate into the affairs of the manufacturers based on a complaint. So these regulators have wide scope. So the consumers have a better protection. They can make a complaint to the regulators who will look into the affairs of the manufacturers or the service providers. A mediation has been introduced. Appeal for the any order passed by the mediator or the regulators can go to the forums. E-commerce has been introduced, which was not there in the earlier act. A review is allowed. Earlier it was not there, it was only an appeal. Now a review has been introduced. Any order, we can apply for a review petition and get the order reviewed. Unfair trade practices and the terms and conditions have been introduced here. The authority has been introduced. Video conferencing, which was not there earlier, has been introduced. Composition of state commissions. So any composition can be done at the state commission level. Next slide. By and large, procedure for conducting the case will be the same. Only thing is that all these consumer matters are fast tracked. and the fast track has also been introduced. It is not a, it's in the nature of a summary suit, and typical trial will not happen, but of course the CPC, the Civil Procedure Code, will be followed, and it will be consumer friendly procedures, and it will be time bound. That is, within 30 days you have to make an objection, and then evidence, argument, and then the order will be passed. So the entire thing, they are trying to finish it within 90 days or 6 months. So this is what is expected. The procedures, and if the objections are not filed within time, it will be an ex parte. So I have been able to see that now during our practice. So the procedure by and large is going to be more fast track. It's a welcome gesture for all the consumers, and it's good for the advocates also to close the cases speedily, and they also can give the benefit to the consumer. So it's a procedure wise, it's going to be, there are going to be a lot of changes to come. Next slide, Anushka. So now that the product liability, misleading advertisements, and more consumer rights, and the online transactions have come into the Consumer Protection Act, or the manufacturers have to be very careful in terms of their warranties, product guarantees, advertisements, and service aspects. So the consumer is getting lot of protection under this Amendment Act, and also his scope has been increased, so that the manufacturers have to be very careful, and a claim can doom their products, their reputation. So disclosure levels have to be very good, and the changes, features in the product, warranty terms have to be informed to the consumers, and they should be able to make available all the spare parts if a product has been sold by them, and at no point of time they should be saying this is an old model, I don't have a spare part. Make disclosure or disclaimers at the initial stage itself, so that the manufacturers need not face challenges when the consumers file a case. Otherwise, there are chances that they might end up in paying compensation for non-availability of spare parts or services. So the manufacturers have to be very careful on these lines. Redundant products, they can call back, and all they can return, or tell them that, give a warning that we will not be providing henceforth, you please take a action or take a decision now. So these kind of proactively coming to the consumers is better than keeping silent. So it will help them when there is a claim that we have already informed the consumer. So this is something which they can contemplate. But as such, now the act is not been aware, then the new amendments are not reached the public. So it's a slow process. More of awareness programs will come up. People like us should start educating the manufacturers and the consumer that, look, there's a amendment which has come in and which protects, and it has widened the scope. Next. So to conclude, the act is a welcome change, of course, in favor of the consumers. It provides them with clearly defined rights and dispute resolution process, which may enable them to resolve their grievances on a fast track basis. On marketplace and online auction sites, which have all throughout been included under the purview of an aggregator, also plays a vital role in inclusion and more responsibility on the goods and services. So, to conclude, the Dispute Resolution Amendment Act has really empowered the consumers to sort out their grievances and seek remedies. So, the manufacturers and the product line manufacturers or the e-commerce have to be very careful on the assessment and product liabilities. So if there is any questions, please let me know. I'm here.
So, yes, I must say it was a very enlightening session. Thank you for giving us so good insights and for the Consumer Protection Act. I mean, it was really enlightening. In fact, knowing how the changes have occurred and how, in comparison to the old act, what are the new things for the consumers and how they can avail these rights. This is something which was really in demand for everyone to know. So I would like to thank you for that. Yes, we do have a couple of questions. So, like we were discussing for the like for the companies and the manufacturers, as in what are the challenges and compliances for them. So in case if the company or a manufacturer is caught to infringe the consumer right, in that case how is the investigation process under the new consumer act?
Okay, now the rules pertaining to investigations are available or it will be made available. So they have a set of uh, people at different rank will, upon a complaint by the consumer or suo motu, can investigate the manufacturers or the different products which is a subject matter, and such findings will be useful for both the manufacturers and the consumers going forward. But as there is an investigation authority available, so the manufacturers have to take this more seriously, and uh, they should not indulge in any false promises, advertisements, or warranties guarantees which they fail in meeting. So this is how they can overcome these challenges. Of course, going forward, once the act is, the awareness comes into the consumers, the litigations are going to increase in numbers. The consumers will start fighting for their right and they will start using the investigation process as well. So the manufacturers and the companies have to be a bit careful from the beginning itself, and a lot number of disclosures have to be made by them.
Yes, thank you, sir. And the other question is like in what circumstances the service provider will not be liable for product liability, as we were discussing that in what cases how the product liability is to be enforced, and in what cases such liability can occur. So, what will be the circumstances? Will it will not be a liability of a service provider?
See, when it comes to a service provider, the main question is, I have approached this service provider for this service. And if the consumer is not satisfied or the service provider has not fulfilled or there is a lapse, then the complaint can be lodged with the appropriate forum pertaining to the precautionary jurisdiction. So if there is a lapse from the service provider for not fulfilling their promises or the service levels, then he is liable and accountable. But if we can establish that there is no lapse from his side or the services which they have promised has been delivered, in that case, the forum does not penalizes them or slaps compensation on them. Mainly, the documentation process is very important for every service provider. Be it any product, when there is a service call, the person who goes there, provides services, have to make a proper document in a very legible language, take the consumer's signature and keep the documents available. Many of these documents are not available since we are in that space practicing. These documents will help the service provider if there is a grievance raised by the consumer. So proper documentation and providing timely services is very important for the service provider. Otherwise, there can be there can be chances for them to be liable and compensation can come on. Any more questions?
Yes, sir. So, like we were discussing about the mediation process. In that case, like what are the matters that can be referred to the mediation?
See, an option is available for mediating, but of course, both the parties, the complainant and the uh, service provider or the manufacturer has to accept. When the complainant is agreeable for a mediation, the process can be initiated on it. The member will refer it to the mediation center, and then the mediation starts. It could normally it will be a face-to-face meeting where the mediator and both are sitting across the table and arrive at a solution. So basically, there are certain areas where uh, you can't quantify the mental agony or amount of damages, or there is no documentary evidences for both the sides. In such cases, mediation definitely helps a lot, which is not available in the previous act. And this can help the both the sides in coming out with an amicable solution, across the table. Mediation can be, giving a price refunding or replacing or part replacement. So all these things can be solutions which can be arrived in the mediation. So this is a process where the manufacturers or the service providers also learn how to deal with consumers, and it is actually meeting them and understanding what is the consumer dynamics and behavior. So this mediation process definitely will go on a long way. If you take the time span of 5 years, then the manufacturer or the service provider will know that yes, these are the things which the consumers react to or their behaviors, and they can improvise in their system. So it's a good process actually. and it's not time consuming. In 1 or 2 sittings the whole thing can be over, and it has been done in a place, in a common place, where to suit their timings, they can fix their time and come. But in the court, it's the court gives you the time, or the forum gives you the time. So here it is not, so you can have it, and it's a very consumer friendly, and it's a win-win situation for both.
And so, like, is there any time period under which the mediation process is to be completed between the parties?
Normally it is 1 or 2 sittings, that's it. And if there is if there the mediation center is not able to arrive at a decision, or the it is not successful, again the matter goes back to the forum. So the mediator gives a report, and it goes back to the forum. So that is the process.
And if one of the party does not attend the session or the meetings for the mediation, what will be the consequences for the same?
If there is a genuine reason, definitely you will get a date. Otherwise, the mediation center will give maybe one chance they can give, or two chance maximum, and they can refer it back to the forum for non-cooperation or whatever it is, or they can pass an ex parte order also.
Okay, sir. And so there's a deficiency of service that is under the Consumer Act. Like, in what circumstances this will be applicable, and to whom it will be applicable?
Service, when it comes, when there is a product, for example, you buy a laptop, and your system is slow, you are paid say 60,000, 1 lakh for a laptop, and it doesn't give you the speed, it doesn't uh, give you the desired result, or the pictures, the video, the volume, the motherboard, or the key doesn't work, and then you call for a, you get back to the manufacturer, and he sends one service provider or a person to come and repair your product, and after repair also your product is not working fine. So that is when you start saying that there is a deficiency in service. Or if your product is not working, you give a call and nobody is attending, and due to that you have lost damages, you have lost the opportunity. So there comes the deficiency. The customer care services have to react immediately. For example, you order something, say through Amazon, or say Flipkart, any product, and you wanted certain things to be, they have mentioned that it will reach you by within 3 days, and it doesn't come, and they don't inform you, there is a delay, or they give you a false hope, and they ultimately deliver it after 15 days. By that time, you don't have that product, you couldn't use that product, you could have purchased it outside, the purpose was not served. Or some, for example, you wanted an oximeter, and it doesn't come on time, and somebody was not checked for want of this. So it can be a cascading effect can be there. So this is all called the lapse of, a deficiency in service. So whatever is committed, the service levels, whatever you commit, if you say 3 days, yeah, it should be in 3 days. If it is going to exceed, you have to tell the reason, or give the option to the consumer, disclose yourself, don't keep them in dark, communicate. Hey, I have a problem, I'm not able to do this, you better buy it. Disclose them, but don't keep them in dark and say, no, it's coming tomorrow, today, all those things, covering up the whole thing. If there is no stock, upfront tell you, so that the consumer goes somewhere else and buys. disclosure is very important. Otherwise, there will be a deficiency in services, and then it's going to become a big problem.
Yes, thank you, sir. Of course, we should not keep our consumers in dark, and disclosure is very important. Well said, sir. Moving ahead, in your opinion, the mediation that has been inserted as an redressal mechanism, do you think like there should be other mechanisms of area that should be instituted, or this is sufficient for India right now?
The mediation has been there in all the other courts, especially when there is a sensitivity involved and your product has been discussed in an open court. This is really helpful, and it's a welcome idea that mediation has been introduced where it becomes more of in camera discussion and it need not be spoken in the public. So, mediation, yeah, we have to see how it works here. The important point here is the complainant has to accept it. The normally the service provider, the manufacturer will look for mediation. However, the complainant has been rubbed somewhere, or he's got a sense of. Normally, a consumer doesn't wants to file a case. There is going to be a small disturbance. He's going to bear it, but there are circumstances where he feels hurt or his ego is hurt, and he determines to go to the forum and see that his right is emphasized. All these things are coming from right. When your desire is not fulfilled by a product or a service, you are not satisfied, then for the deficiency, definitely the consumer is going to knock the door. And the major uh, player will be the presiding officer to refer the matters to mediation. They should be the guiding force, so that they are not put into a situation where they have to make a compensation or penalize a company and awarding a huge damages. For example, there are new provisions which has come in, like advertisement, misleading advertisements. So these are all going to be going forward. It is going to be playing a vital role. A celebrity has advertised a product, and that product has not reached or satisfies the purpose, and the celebrity is also taken into task. So these things are going to come up. So these areas mediations will play a big role. I think it's a welcome idea, and I think people should opt in.
Yes, thank you. So, like, I do agree with you with enrossal liability coming in light. It will be though challenging, but again, for the public, when you're seeing a public figure actually advertising for a product which is well known, and if you tend to come across something which was not expected from that very product, it is quite disappointing. So, of course, everyone, as you have said before, you should never keep your customers in dark. So yes, these things will surely happen. I do agree with you. Well, again, I would like to thank you for giving us such clarity on this act. Well, before that, there's a small announcement for our viewers. Please fill up the attendance form for e-certificate. The link has been shared with you. Secondly, if you have any other queries or questions, please mention in the comment box. And thank you very much, sir. Again, I must say, as a moderator, I really enjoyed, and it was a very engrossing conversation with you, sir. Thank you very much. And I would like to extend my sincere thanks to Lloyd for uh, coming with such a session. Thank you very much.
Thank you, Anushka, and also to Lawyer for giving an opportunity to talk to the viewers. I hope this session was useful. Any feedback you can send it to me. Thank you very much.